right, can everybody see the screen for the presentation?
I can see it.
Yep.
Fantastic. All right, so my name is Billie Tarascio. I am the owner of Modern Law, which is a family law firm in the Phoenix area. We have 10 different attorneys, and we only do family law. I personally went through a divorce while having a business and love business in general as a business owner. So this is something that I'm really, really passionate about. And I want to introduce you my friend Juliet.
Hi, everybody. I'm Juliet Peters, and I am a business lawyer. All I do is business and a lot of business sales, which is where typically sometimes this comes in. And I don't have 10 attorneys. I only have a handful of independent contractors that I work with, but I'm able to build out teams as needed. So I'm super happy to be here because this is also a topic I am very passionate about, not only for those who are going through divorce, but also for people who are buying businesses and who may stumble into one of these situations, which happens quite frequently, actually.
Absolutely. And even if you're not going through a divorce, if you are just a married business owner or you're engaged as a business owner, like this webinar is for you, because as lawyers, we either do two things. We either prevent messes or clean up messes, and we would prefer to help you prevent the mess and the litigation. So hopefully you get some tips here today that help you do that. No one plans to get divorced, which is crazy because, we all know the odds, but nevertheless, when we are getting married, we mean our vows.
Yes.
No one gets married thinking this is going to fall apart. And some people who maybe do get married and think this might not last forever still don't usually take the precautions that they need to in order to protect themselves and their business. Prenups have a bad name, so we're going to talk about that. Community property, the impacts on your business, and understanding what you can do about it. So let's see. The basic ways to prevent an issue are a prenup, a postnup, and then your business documents. So I'm going to talk about a prenup and a postnup, and Juliet is going to talk about business agreements. Now, they can all handle these issues or address these issues. And one thing that you need to understand right off the bat is when you get married without a prenup or a postnup, you are opting into a construct. It's just not the construct that you chose. It's the construct that the Arizona statutes provide. So one way or the other, when you get married, when you say your vows, there is a rule around what will happen in the event of a divorce. Now, if you do a prenup, you get to decide what are the rules that work for us and our family. If you don't, then you're stuck with the rules that the Arizona legislature wrote. And that comes from a theory of community property. And the theory is important to understand, and we'll get to that in a minute. But what you can do with a prenup is you can decide in advance, hey, what happens to our property? And it doesn't have to be, you don't have to decide when you get married that you know exactly what will happen to your property. You can decide on a process. So you could say, listen, in the event we get divorced, we agree we're going to use a collaborative divorce process. You could say, we agree we're going to use mediation. You could say, we agree that whatever property we came into the marriage with, we're going to keep separate, and whatever we title jointly, that's what we intend to have jointly. It can say whatever you want. It's not like a set thing, which I don't know that a lot of people understand. The other option, if you haven't done a prenup, is you can do a postnup. A postnup is simply an agreement that's entered into with the spouses that is after marriage, and you're talking about like how you're going to handle your finances while you're married, and then what happens in the event of a divorce. You also have to have some consideration. So you definitely need to work with a lawyer on a postnup, because it's not as easy as like having your spouse sign away their rights once you're married, which some people do, and that won't work. That will get overturned. And then the third way is business docs. And Juliet, I'd love it if you could talk about that.
Yeah, absolutely. So I would say probably the single biggest factor, and I don't care if you're find yourself in a situation where you're ending up divorced or not, the single biggest preventative measure that you can take is having an operating agreement. And I could sit here for the next 3 hours and talk to you about how many businesses do not have operating agreements. And so if you don't take the time to do the operating agreement, you leave yourself in such a vulnerable position, because although Arizona has a relatively new law in the last few years that has really kind of shorn up what we were doing with limited liability companies, for example. There's a lot more in the statute now. You do not want to find yourself in the statute. You really want to make sure that you have thought through all of the possibilities, divorce being one of them, as to how you're going to write your operating agreement, because that is, as we say, the rules of the road for your corporation. It's called an operating agreement if it's a limited liability company. And if you are a C Corp or a professional corp, then what you're talking about are kind of a group of documents like bylaws plus a shareholders agreement. The shareholders agreement is really what talks about what happens if something goes wrong, a divorce, a death, some kind of disability. So again, you really, really need to have that operating agreement in place. And as part of that operating agreement, I, in my own practice, always deal with the eventuality of divorce because it's so commonplace. And I am the person asking, do you have a prenup? If you do have a prenup, then we set the operating agreement up so that your spouse is signing a disclaimer, right? So that it's very clear that that property is sole and separate property. And even in the event that it's community property, spouse will sign something so that they're acknowledging, hey, I have rights under this operating agreement, and I've agreed to take other property, for example, other than the interest in the LLC. Because what you don't want is you don't want to be feuding. And it pays a lot, especially if you are a husband and wife owned business, to really discuss these eventualities before they take place. I know it can be uncomfortable, but honestly, if you talk about it when times are good and deal with what you need to, it's so much easier to unhook once something actually happens.
Absolutely. And one of the things that you can do if you're married and you have a business is, like Juliet was saying, the laws changed recently. We didn't used to be required to have an operating agreement in Arizona. And so all you had to do was file your documents and then poof, you have an LLC, and then you're opting into the laws that were written, right? It's not like there's no rules. The rules are what was written. So, but what you can do now is, if it can be a little awkward, but you can go to your spouse and say, listen, I was talking to my accountants, the laws have changed. We have to do an operating agreement. And as part of that operating agreement, you get to decide a lot of things. And this webinar is going to go over, like, what are the pitfalls? What are the disaster and the horror stories that we've seen, and how can you avoid them? Because you've got issues of valuation, you've got issues of control, you've got issues of operation, you've got issues of data valuation, and all of those things can be addressed in the operating agreement in a way that protects both of you, but most importantly, protects your business, which is its own entity, which is fragile and can be decimated by divorce.
No question about it. That is so well said, because if you don't take the time ahead of time, you end up with all of these weird situations happening when people are angry and you don't have a roadmap, which is the worst place to be.
Right. And then, we'll talk about what the family court can do and what they can't do. And sometimes people have 2 lawsuits, and we want to help you avoid that. So the first question, and the most important question that I'm going to look at when you come to me and you are talking about divorce, or you need a divorce and you've got a business, is determining the character of the business. So character of property refers to, there's only 2 characters in Arizona. There's community property and there's separate property. And then I guess there's quasi community property, but that's really just community property. And what quasi community property means is that you acquired your property in a state that is not a community property state, but we're going to treat it like it is. So really, there's community and there's separate. Now, everything that you acquire, debt and property, after you're married, if you don't have a prenup, is community property, unless it was gifted to you or inherited by you. That's it. It's really simple. If the property existed before you were married, it's separate property. If it started after you were married, it's community property, unless gift or inheritance. Bright line rules. Now, so we want to look at where the money came from when you started your business. Did it come from you? Did it come from someplace else? And that's going to be our starting point. Now, even if your business is separate, it doesn't necessarily mean that your spouse doesn't have an interest. But community property, all community property has to be divided equitably, which means equally in terms of value. So you don't have to necessarily each of you take half of the stock in the business. You don't have to take your 50% ownership and your 50% ownership. You can trade for houses or retirement accounts or anything like that. And if the business is separate property, if you started it before you were married, your spouse may still have a claim to a portion of growth. And that comes down to the theory of community property. So the theory of community property is once you get married, you are now a new entity that is community. And each action that each of you takes is on behalf of the community. Now, this is like a partnership theory, which Juliet is extremely familiar with. It comes from this idea of partnerships. And when you're a partnership, each can bind the partnership, each acts on behalf of the partnership, whether or not it's in the partnership's best interest. That's true with community property as well. So because of that, if you work your labor and you grow your separate business after you're married, the fruits of your labor create a community lien, become a community asset. Whereas if I have a client whose wife owns a portion of her mother's company, but she has never worked for a day in her mother's company. Now that has grown over the course of the marriage, but he has no interest in that growth because nobody worked. There were no efforts. It started as separate, it stayed as separate. Let me know if you have any questions on that. Story time. This is the first of our stories. Now, Juliet, you said you had a great story.
I did. I had a doozy that dropped out of the sky this morning. So, and actually not involving, I was not talking to the owner of the business who is getting divorced, but a buyer of the business who was vetting the business, quite a sophisticated business owner, looking at an opportunity, and two things came up, and I'll focus on the community property aspect and not the wholly other weird thing, which is a minor owning an interest in the business. In all my years of practicing, I've never seen a minor with an interest. So in this case, this guy has two really significant issues, but the community property issue was this. Wife owned the business and had been actively working in the business for 10 years. It's a franchise. And married the spouse in 2019, filed for divorce in December of this year. And so we don't know whether or not spouse worked in the business or not. But now the question that the buyer has is, does she have the capability to sell the business right now? And how do we, as the buyer, protect ourselves because we don't know what's happening there? And so we talked about the practical impediments and how you kind of handle that. But, a buyer is going to want to know, hey, I'm not going to be the one that ends up with a terrible situation here because you're in the middle of divorce and it's not clear. Of course, that business, right, was sole and separate property coming into the marriage. Mm-hmm. But what happened in that 2019 and what the potential new client asked me as well, can we get a disclaimer from the spouse? And I said, I think it's a tricky time to get a disclaimer because wife is represented and spouse is not. So, it's mixed up with where they're at in the divorce proceedings. And I would let, Billie weigh in on that, but it puts the whole thing, it's very fraught, right? because you're in a situation where, in this case, spouse could be the one who is more vulnerable, does not have a lawyer, whether or not there would be any validity to a disclaimer that would be entered into, after the divorce was actually filed. I don't know, but I'm guessing it would put it at risk. So, I think those are kind of the issues that you have to deal with, because it's unclear. I mean, that clearly something is going on, that this woman needs to sell this business. The problem is, what does the buyer do? Because the buyer has no idea what they can do to shore this up in a way that does not put the buyer at risk.
Yeah. So, ladies and gentlemen, to put this in another way, if you're interested in selling your business at any point in time and you don't have this in here, your business now becomes riskier and less valuable. This is another reason that you can use to talk to your spouse to figure this issue out, to make it a little less awkward. So you're not talking about what happens in the event we get divorced. You're talking about what happens in the event we want to sell. How do we make our asset more valuable?
Right.
Now I've got a hypo. Oops, what's going on, guys?
Audio technical difficulty.
All right, so hypo question. Firm is owned before marriage. It's a personal injury firm, and all of the fees are contingency based. Then a divorce. What interest does the spouse have in the fruits of the labor? So the question here is, like, this person owns a personal injury firm. All of the fees that they get are based on contingency. So they get those fees on the back end, and they're wondering how the fruits of the labor would be measured. Okay. So if this is a personal injury firm and you own a passive interest, then the spouse would have no interest, right? You own a passive interest. You are a shareholder, but you don't work. Now, that's probably not the case. Probably this person works in the business and has grown the business. And the business started out a certain size, and then it grew to a certain size. And the question is, how is the community interest valued? Well, that comes from a case called Ruschenberg. And essentially, what you have to do is figure out first of all, it is the burden of proof of the non-owning spouse to show that growth occurred during the marriage. That should be fairly easy, but it's their burden of proof. So they honestly, by looking at gross revenue on the date of marriage or the year that you got married and gross revenue now, you should be able to tell, between profits or the top line or the bottom line was their growth. That should be pretty easy. Once that happens, then you need to determine the value at the date of marriage and the value at the date of service or the date of divorce, whenever you decide that date of valuation is going to be on the back end, which is, in this case, when it's sole and separate property, it's stronger argument to say that the valuation date needs to be the date of service. If it's co-owned, then the valuation date can get trickier, and we're going to get there. But so you have to figure out the two values, and then it's not everything that happened during that marriage. It's determining what portion of the growth is attributable to the community and what portion is attributable to outside factors like increase in rates for attorneys, increase of car crashes, things that you have nothing to do with, increase in property value if you own property. So the bottom line is, it's a very complicated case where you usually have two experts, or the two of you have to decide on one expert, and then you battle it out. It's not easy. And I do have one of our stories about that, but let me go back to my screen and we'll tell you about this story, the printer. So our client was the printer. He owned a printing company far before he got married. He's on his second marriage. He's married for 7 years. There are 3 LLCs that are started before the marriage: the printing company that funds everything, a holding company that didn't really have anything in it, and a third company. No activity in the 2 companies, only activity in the printing company. Then once they get married, they start doing activity with the other 2 companies, including buying a cabin, putting money from the printing company into the new company. Messy, messy, messy. The books were messy. You couldn't tell what was funding what. And we ended up at a temporary orders hearing for an hour to figure out on a temporary basis what happens. And the judge couldn't make heads or tails of what this was, couldn't determine what this person's income was, couldn't determine which properties were sold and separate. And if you don't have both a lawyer who's crystal clear on how to analyze what is what, and then enough time in front of a judge, you end up with a debacle. And that's what happened here. The judge ordered that she get us, continue to get a certain thing from the community business, but didn't define what the community business was. And then there's the fact that the family court judge cannot order a community business or non-community business to do anything because the family court doesn't have jurisdiction over a business. The family court only has jurisdiction over the people. So bottom line is it was a gargantuan mess that really can only be avoided by keeping your books straight, being real clear about what's income and not, making sure that you're clear on what personal expenses you're running through your business. Like this can be a real conundrum.
And really, outside of even the divorce context, I will tell you, as someone who works every day with people who are buying and selling businesses, messy books are they're the bane of everyone's existence. That's why, I mean, the statistics are really shocking. Like out of the businesses who get offers to sell, which is a teeny tiny, really minority of businesses, like 7%, right? Are the winner chicken dinner on that. 80% of those sales don't close. And what's one of the reasons they don't close? This messy book situation and running a lot of personal expenses in. That's a whole different, webinar on bringing a lot of discipline to your business. But one of the biggest discipline points are, number one, keeping your books really clean. Number two, keeping your entities and what they're doing really clean. And number three, having an operating agreement. I know by the end of this, I'm going to sound like a broken record, but honestly, that saves you so much aggravation, no matter what the unknown that comes up in your business is, even if it's divorce. Having the operating agreement is key.
Absolutely. I mean, absolutely. So one of the things that you can do if you think you might be facing divorce at some point in the future is make sure your business is healthy. That means like you have good people who are running it. You have good systems and processes. It's not going to fall apart because divorce is a massive stressor on a business. Now, we were just now getting to this slide about the Rauschenberg analysis, the growth being passive or active. I'm not going to go over it again. If you have other questions about that, let me know. But I do have a story about this type of analysis. So in this particular case, we had a day trader. Husband, married wife, second marriage. Husband came into the marriage with $10 million. No one worked a traditional job, but by the time they got divorced, this $10 million had become $55 million. And his claim was this is all sold on separate property. Now, he worked every day. He went into his office every day. He traded stocks every day. We argued the growth that was based on his labor. And because of that, she was entitled to a portion of that growth. Then what we had to do was hire different experts to figure out how much of the growth was attributable to his work and how much wasn't. That's the Rauschenberg analysis. Now, in this particular case, he was working. So the judge found he was absolutely actively working in the business. However, the trades that he made were actually losing money. And the growth that went from the 10 to 55 was really due to one particular stock that had been inherited. So when it came out in the wash, she did not get any of the growth. Now, she did get a fat amount of child support based on the Steve Nash case and a good amount of spousal maintenance. So she was fine, but actually figuring out this idea of determining, is it passive or active, isn't easy. And none of us knew until after all the experts had gone through the analysis.
Billie, let me ask you a question, because I think this comes up a lot when I have husband and wife owned businesses, right?
Mhm.
And they're
Mhm.
both actively working in the business,
Yeah.
right? What happens in cases like that? Because they both have their individual interest. I mean, and I'm trying to, at the beginning of the relationship, right? I'm trying to bake in all of these things into the operating agreement. But as a business lawyer, I'm thinking, okay, well, how does this unwind on the back end? And so if one of them
Hi there.
leaves, right, they're both working actively
I
in the
am
business,
CLEing.
that
Okay, sorry. Wait a minute. Somebody is not muted and we can hear you. So please put yourself on mute. Thanks.
anyway, so that my question is, how does that sort of that adds a whole different wrinkle, I think.
Oh my gosh, that's such a great question. And that is where we're getting. So, Juliet, just to sum it up, because we got interrupted a little bit.
Right.
Two parties, married couple, starts a company together, working in the company together. Once somebody files for divorce, what happens?
Right.
This is a disaster. This is the hardest situation. It is much easier when somebody owns the business, somebody's operating the business, somebody else has a different job.
Yep.
But when you've got a situation where a couple is divorcing and they're both independently paid by the business and the business depends on them both working in the business,
Yep.
that is the most dangerous situation for a divorcing couple and the business.
Yep.
And figuring out in advance who is going to run the business is a good idea, because both people trying to run the business sometimes works and sometimes doesn't. And there's pros and cons to people trying to continue to operate a business together while they are going through a divorce.
Yep.
I'll tell you, people might start off amicable, but the process has a way of really discouraging that from continuing. So figuring out who's going to be responsible for what is really important. I've got a couple of different stories here that are going to illustrate why it's so important to figure this out.
Yep.
So we were just talking about this, the accounting firm. So here's one of the stories. Husband and wife have been married a long time, 30 years. Husband is a Oh, is this the one? Was this your story actually, Juliet?
Accounting firm. No, I don't
I'm going to
think-
still tell you the story that I'm talking about. So,
yeah, I don't think this was mine though.
okay, great. So we've got husband and wife that own this accounting firm together. It's actually like a financial.
Oh no, this is mine. This is changed to names have been changed to protect the innocent. No,
Right.
Yeah, got it.
Okay, well, let me continue telling you about this. So
Yep.
this is a financial services firm. Wife runs all the books, runs the business, pays all the bills, makes sure that the day-to-day happens, right? The operation side, and husband is the financial services provider.
Yep.
They continued to work in their business after the service of the petition of divorce. And here's what happened. Our client is wife in this situation. Husband stopped working. He stopped selling, which happens a lot. And there's a couple of reasons. She's like, look, he's depressed. That's real. That's real. It's really hard for a person who's going through a divorce to maintain the same level of focus. And I'll tell you personally, from going through a divorce, when I was going through a divorce, there was a good period of like a year where I couldn't do a consultation. I couldn't sit down with somebody and hear about their divorce because I had my own stuff. And luckily I had a team that kind of like just picked up my slack. But in this particular case, husband kind of stopped working. Wife was doing the best she could. She continued to take a salary. He continued to take a salary. The value continued to go down.
Yep.
Then at a certain point, an investigation happened from the SEC and they got locked up.
Yeah.
And now the value is even lower.
Yeah.
Now my client, wife, knew she didn't want the business long-term. So she would have been much better off figuring out how to give him the business at the date of service and go to find a different job. That would have been better for her than, and she wasn't my client at that time. She came in later. than waiting and trying to work together. And that wasn't because they couldn't work together. It was because the behavior and the things that happened during the pendency of the divorce were not good for the valuation and for her buyout.
Yeah, and it gets even the other thing that I've seen happen that is very troubling is if one spouse is really the only owner of the business, but the other spouse is working in the business and has been working in the business, but don't have any ownership on paper, then things like lockouts occur where the spouse changes all the passwords and, but the spouse doesn't have the skill set to be able to do the work that the other spouse was doing. So it can get really messy. And I mean, I think that when you kind of put these eventualities into an operating agreement, it helps. But the one thing I will tell you is you're never going to be able to 100% bulletproof business against behavior that's driven. Yeah. I mean, you can't fix depression that way. You cannot fix, domestic violence. There are behaviors that even dealing with this stuff on paper is not going to insulate the business against, but you can get there. I mean, it gives you the ability to be able to go into court, for example, and, get an order of some sort. So on the business side.
Yes. So let's say, what can you do in advance? You can make sure if you are the business owner and you want to keep the business and you think that there might be a divorce one day, you need to make sure that your spouse is replaceable. Bottom line, in your business, that their duties are documented, that you know how to have it be done by someone else, and you know how much it's going to cost. And then the faster you do that, the better. If you are the spouse that wants to keep the business, the faster you replace your spouse with somebody else and pay somebody else to do their job, this is going to impact your valuation in a correct way. You are going to have to pay someone to do the job, and you want the business and the books to reflect that cost because it's going to impact your valuation.
Yep. And I think the other thing is Billie, you can really, when you're having these discussions, you can, wrap it in a different clothing, right? It doesn't have to be divorce clothing. It can be disability, it can be death, because in either of those situations, disability and death, which people don't like to talk about either, but I'm sure they like to talk about it more than divorce.
Yes.
It's like, it's about what's the practical planning, all these things that you hear that you should be doing about, having records so that, if somebody gets hit by a bus, you've got all of the passwords and all of the financial data and all of that stuff will work just as well for divorce. It really will.
Right.
But there are things like, bank accounts and things like that, where you have to really think about those things ahead of time, because you could get locked out. And really, I mean, I've had lots of issues where people are at the bank, right, trying to do this, that, or the other thing, and they can't because they don't have the right documentation. It doesn't matter if it's a spouse or a partner who's gone rogue, a business partner. It's the same thing. You have to set yourself up for success by taking those practical steps and getting those practical, things in place so that if something happens, you've got a way to deal with it.
Absolutely. Our next topic is income and valuation. So valuation date, we touched on. Usually when you file the petition for divorce and serve that petition for divorce, the date of service is when the community ends. And that means all of the actions that you as an individual take after that are no longer for the benefit of the community, but they're on your own behalf. So any money you make is now yours and not the community's. So the valuation date of a business really depends on who owns the business and who's working the business and who's keeping the business. We have the discretion, and the judge has the discretion to decide the valuation date. So, and there's another story coming about a valuation date issue, but the next question is the income from your business after service, community, or separate? Let's say that the asset is a community property interest. Okay, we'll take my law firm, for example. My law firm was opened during my marriage. It is a community property business, but only my name's on it because only lawyers are allowed to own businesses. So his interest is equitable not practical. He has no legal authority to act on behalf of the business. That's easier. When you have two spouses that are both members or both owners, that's harder. Then the next thing I'm looking at is who's the president and who's not, because the president is allowed to fire anybody else, and then they'll have to go get another job. Now, does the president then get to keep all of the income from the community business? Maybe. Any income that is from your work that is a reasonable salary, you get to keep, because you're working on your own behalf after the community ends. But if the community business is making more money than a reasonable salary, then anything above that reasonable salary is split, because those are profits. Those aren't money for your labor. They're money that comes from the asset that is owned by both of you. If there's any questions on that, let me know. Okay, we already talked about this. How do you minimize your risk? Juliet, you want to talk about this one?
Yeah. So minimizing your risk is a pool of activities, right? You definitely want to make sure that you have a plan in place for what happens in a business where there are two working spouses. You want to have a plan in place for what happens when something happens to someone else. And that will work equally for divorce as if somebody has a disability, right? If you are the spouse who is not working in the business, right, you want to make sure that you at least have some eye or some view into what's happening with the business. You don't want to be running substantial personal expenses through your business. You do not want to have financials that are in a disaster state. It's very easy when we're in a relationship, particularly if you're the spouse who's not working in the business, to let that sort of go on its own, right? It's really risky if you do that. You have to at least have a monitoring hat on. You don't have to be thinking to yourself, I'm getting divorced in 5 years, I've got to monitor this, but you really need to understand how that business is operating and some of the, business dealings that are happening. Things like guarantees that are signed, all of these issues are things that you have to have your eye on. You really need to make sure that the operating agreement deals with whatever your personal situation is. So if you have a prenup, good for you. You want to make sure that you're signing a disclaimer. But if you sign a disclaimer, you have to understand what that means if the eventuality actually happens that you get divorced, right? That you're drawing a line there and you have to be comfortable with that line. If you are a non-working spouse, you still should read and review the operating agreement, because you've got to sign it, right? You are acknowledging to the entity, which is the company, hey, I've got rights, and this is how we're going to handle these rights in the event of a divorce. Because most operating agreements basically say the non-working spouse is going to take other property and or cash or money in exchange for the interest in the business. So you're never going to have a situation where you're, for example, forcing someone to sell the business. I will tell you, I did have a story, which was a very strange situation in the summer, where it was the non-working spouse. They actually filed and were divorced. She was awarded in the property settlement sort of the proceeds from the sale of the business, because the business was going to be sold. Now, mind you, spouse never worked in the business. She didn't really know much about the business. She was a smart cookie, but she was passively monitoring it. Well, then what happened is husband lines up a buyer, lies to the buyer, or ex-husband by that point, lies to the buyer, tells the buyer they've got all of this revenue in the business, and sends to ex-wife a document that has to be signed, which is the purchase agreement, on the night before the closing, right? Ex-wife goes, this is basically my settlement, and what in the heck is happening here, right? So ex-wife hires me to help her with the business sale of it. And it was very uncomfortable for the buyer because the buyer thought they were dealing with husband. All of a sudden, ex-wife pops up and a lawyer for ex-wife, and they've got to reset the whole table. Turns out he walked away from the business, left it in the hands of the buyer who didn't even own the business. And the value of what wife expected to get out of the business went right down, right? And she got a lot less than she was expecting to get because husband abandoned the business. Now she has some opportunities for making that good in the family court, but she's going to have to spend a lot more money to do it.
Right. That is not your best bet.
No.
Your best bet, like this is your baby. Your business is your baby. It is a valuable asset. And your very best bet is determining early on who's taking the business and what's the date of valuation. And then stop, like get out, go your separate ways. And the cleaner you can make that, the better off your business will be and each person will be, because businesses are fragile.
Yep.
Fragile, fragile, fragile.
That's actually, I just talked about that one. That was a retail store. That's the one I just talked to you about. And the bottom line is for ex-wife, she came away with a lot less than she could have gotten, setting aside his shenanigans, because there were a lot of shenanigans, which will be dealt with in the family court. But the bottom line is the value of the business took a ginormous hit. And you in effect had a buyer in there running the business for 90 days, because husband just said, outie, I'm outie, and just disappeared. So, and we ended up getting the deal over the hump to close, but it was at a great cost to, both the husband and the ex-wife, because the value of the business was substantially diminished by about $1 million, actually.
Yeah. And so her remedy is to go to the family court and say he wasted it.
Right.
But you're trying to squeeze water from a rock at that point. You are so much better off trading the house for the business.
Right.
I mean, and then maybe there's a payment after that, but you're so much better off not getting a judgment for money and getting actual money, like dealing with the actual assets that you have and practically figuring out how to divide them is much, much better.
Yep.
Now, I already talked about this a little bit. What can the court do? It can tell the parties what to do. It cannot tell the business what to do, but the family court doesn't always know that. And sometimes they overreach. And so you have to kind of
underreach.
Or they
I think there was a might have been something I was consulting with you on, or another family law lawyer, where there was a legitimate issue related to the sale of the business and the valuation of the business, and the family court said, hey, we can't do that. We can't deal with this issue at all. And so it left the parties in a really bad situation, because they didn't really have the ability to be able to, to deal with it where it was most efficient to deal with it, which is, at the time of the divorce.
Mm-hmm. Income analysis is another risk. It's very easy to determine the income of someone who is a W-2 employee. They get pay stubs, they have income. We know what that income is. For business owners, that's not how it works. You may have a salary, you then have distributions, you then have personal expenses run through your business, which is normal and fine. You're allowed to pay your cell phone through your business. You're allowed to write off a certain portion of your vehicle expenses. But when it comes to determining the income in the family court, all that stuff goes back in. So you need somebody who knows how to do that and can take the time to figure out that income.
Yeah. And going back to keeping your books clean, there's always a push and pull with business owners. And we talk about this all the time when you're getting ready to, in a non-divorce context, when you're getting ready to sell your business. 2 to 3 years before you start selling your business, you're going to move from, maximizing your tax shelter and protection to maximizing your sales price. And they're two different things. So you're going to pull out all of that personal stuff, not cell phones, not even necessarily a car if you're really in a business where you're using a car, but things like, we see crazy stuff on balance sheets, horses, Really. So unless you're a glue factory, you do not have horses on your balance sheet, boats, cars, houses. In that retail situation I was telling you about, husband was paying his mortgage through the business.
Yeah.
That does
Right.
not belong there.
No, no, certainly not for a valuation. So how do valuations work? So valuations work probably differently from divorce than it does from a sales perspective.
Absolutely.
So how does it work from a sales perspective? How do valuations work? Who determines the value?
So typically you use an outside valuation company, same kind of group of people that you use to value businesses in divorce, although they have usually specialties that are different. A lot of times you're looking for somebody in a specific vertical like manufacturing or whatever, but they're going to apply different discounts depending on why you're valuing the business. So if you're valuing the business for divorce, you're valuing the business for sale, or you're valuing the business for, say, a member buyout, there are different adjustments that are made by the valuators depending on those situations. So the value of a business can be very different for one focus versus another focus because there's a set of discounts that are applied that may not be applied in the context of a divorce. It's a different set of valuation principles. So people who do valuations apply these principles depending on what the unique situation of the business is at the time. Now, when you're selling a business, right, it's what a willing buyer will pay a willing seller. But typically that is, you take the EBITDA number, which is the interest before earnings, taxes, depreciation, and amortization, and it's going to go times some multiple. And the multiple is the magic, and that's going to depend on what vertical you're in, who's your buyer, a lot of different things. But that's not how you do valuations in divorce.
Well, in divorce, you value under all the methodologies, the market approach, the cost approach, the tangible asset approach, all of the approaches, and then the evaluator applies a weight to each of the values,
Yep.
and it comes up with a value. The bottom line is like there's so much discretion
Yep.
in valuations, and the decisions you make during your divorce can impact that valuation. Reasonable compensation has a massive impact on evaluation. And so sometimes we get experts specifically on the reasonable compensation issue.
And one of the things when you're doing an operating agreement, there's always a valuation mechanism in the operating agreement.
Interesting.
It always a valuation. It's always a fair market valuation. It's usually punts to a valuator. But you maybe just think of now, I like to keep the valuation mechanism relatively simple because I'm always looking at it from a partner buyout perspective. If there's multiple members, you don't want like feuding valuations. But if it's a husband and wife business, you might want the more, there's several ways to do the valuation language. You might want a more, you might want that ability to do several valuations and then have them averaged. Billie, you just made me think that in a husband and wife, sort of a closed corporation, I need to think a little bit more carefully about what the valuation mechanism would be, so it's not disadvantageous to either side.
Right.
When I put a buy-sell mechanism in there.
Right.
Yeah.
Right. So what are your buyout options? Well, both people keep working in the business. Both people keep their jobs. That's one buyout option, probably a bad one, because people go crazy during and after divorce. Like it's just one of those life events that like you can't really depend on consistency. The owner of the business will pay support or monthly buyout, monthly payments towards the buyout. Or one of the things you could do is if you're doing on a temporary basis, you can pay the non-working spouse or the spouse that's exiting the business as an advance on the equity or the ownership in the company. And that's a better thing for you to do. If you have to buy out your spouse, that's a better way to do it than paying support, because it'll go towards the amount of money that you have to pay them. But you want to keep it
I have a situation right now like this where it's a longtime husband and wife, longtime business partners together. Wife actually started a business after she separated from husband. They have not yet filed, right? And so she was thinking ahead, and she decided to put him on the Arizona business that she was creating. And so now they each are owners in each of the businesses. And what they're determining now is, how do we handle that? When the divorce rolls around here, one of the interesting things they're contemplating doing is, because she has this other business, there's not very much value in that business at all because she hasn't been working in it. They'll do sort of competing redemptions. And in the main business, because there's a lot of issues that wife needs to provide to the business, they're doing a consulting agreement where the equity will be paid through the consulting agreement, and it'll be paid into the new entity, so they don't have to deal with the tax ramification of that as well. But it's not a particularly amicable divorce, but it's not unamicable, right? And because they are longtime business partners, they at least understand the value of the business, and that's really important. I heard Melinda Gates talk very briefly last night, not the same kind of a thing, because a foundation is distributing money, right? But it was very interesting to hear her take on how she had to deal with the emotions behind continuing to work with Bill while she was going through a divorce every day. So it's really something that that people need to think about if they are in a business where both spouses are working.
Yeah, that's interesting. I would have been interested to hear what she had to say.
It was fascinating. She said, look, there were times where I would go into my office and it was a very, very rough time of the divorce, and I would be crying, and then I'd have to get on, and deal with these issues. But what she said, which is exactly what you said, Billie, is, this was my baby. I helped create this, and I was not willing to walk away from it. So I think it's really important to have that mechanism, that buy-sell mechanism in there, so that you can kind of undo some of the emotions. And some people may not want to continue. Some people may not have the intestinal fortitude that Melissa Gates has. Well, Linda Gates, not Melissa, Melinda Gates. And they may not have that, and that would be okay. So they should have a mechanism to be able to get out if they want to, right?
Right. The last story that I have for you, and then we'll open it up for questions, is husband and wife, married 30 plus years, own an HVAC company together. He manages the HVAC workers, she manages the books. She begins having an affair with the largest customer of the HVAC company. She files for divorce. At the date she files for divorce, the company is worth about $1 million. As time goes on, the largest customer of the HVAC company no longer wants to work with the soon-to-be ex-husband. Wife moves in with this person. Wife continues to work in the business. Husband continues to work in the business. Wife stops working. Wife takes money out of the business. Husband kicks wife out of the business after wife takes money. And then husband decides, I want nothing to do with this HVAC business. I'm done. Business went from $1 million valuation to a $0 valuation. And while Arizona is usually a no-fault divorce state, you can bet we're going to argue about fault in this particular situation. So that's just a tragedy. It's just a tragedy.
Yeah, absolutely.
So that is essentially everything for today. We've got 4 minutes left. What questions can we answer for you? And you can feel free to take yourself off mute. Hi, Anna. Did you have a question?
Yes. I had a business that we opened up in 2004 and that we closed in 2009. And I found out through my divorce that it's been open this whole entire time. I talked to my ex. We were divorced February 14th, Valentine's Day, if I could have the business. And he said, yes. We have yet to go to the commission to go ahead and sign him off. Now, there was no offer made in selling the business. Should there be one?
Okay, good question. So what I'm hearing here is husband and wife open a business, stop operating the business, get divorced, all the properties dealt with, nobody mentions the business, everybody thinks it's closed. It's not operating. Now, wife wants it, husband wants to give it to her. Is there an issue with the divorce? The answer is no. This business has no value. It is technically undivided property. If you get divorced and there's property that you don't divide, that's undivided property. And you can go back and ask the family court to divide undivided property. But you two are basically in agreement that this is zero value and you're taking it. So it's almost, I think you want to get an agreement between the two of you that acknowledges that you're taking the business, that it has no value, and that husband's waiving any interest in it, or your ex-husband. But you should be just fine.
Yeah.
Good question.
And then once you get that, and it could literally be a handwritten agreement that you both sign, just so it's clear what's happening, then you can change you can go to the commission and remove him, and add yourself.
Okay, great. I have to remove myself as well.
Yes.
Okay.
Well, no, you don't have to remove yourself. Are
okay.
you trying to close it?
No, we
Or-
don't close it. What it is he's willing to go ahead and sign it over to me because I'm wanting to restart the business myself.
Okay. So then all you need to do is, if you're already on the business, you don't have to, if you're already on the filing, you don't have to do anything with respect to yourself. You just have to remove him once you get that once you get an agreement in place.
The
Right.
other question I have for you, do I have to change the tax ID since I'm removing it, or just be able to keep it and continue and then start my business?
Yep. You've got a tax ID, and you can notify the IRS via letter but you don't have to. In fact, I wouldn't actually at this point, because the IRS is such a mess. As long as, the IRS doesn't care when you change members. The IRS does care if you change the name of the business. You need to notify them for that.
All right, here's another great question. Let me make sure that my do not disturb is on. Okay, another great question. Divorce is already filed. Is there any benefit to putting the operating agreement in place now? The spouse is not involved in the business aside from a community interest.
Correct.
What do you think, Juliet?
What? Sorry, can you repeat that one more time?
A divorce has already been filed.
Yeah.
Is there any benefit to putting an operating agreement in place now? The spouse is not involved in the business, but does have a community interest.
No, I don't think there's a benefit to doing an operating agreement now. I always think you should do an operating agreement, but after the fact, I'm not sure how much that would actually help you, because what's going to happen is the court's going to value that interest. From my perspective, from a business perspective, I'm not sure it's the right time to do an operating agreement now. Billie, from the family law perspective, I think that would be weird to do it now, actually.
Okay, so it's a great question. So
It is a great question.
My only thought is if you die, having an operating agreement might be a good idea so that it doesn't get given to your spouse. But honestly, I don't know. It shouldn't make a difference in your divorce. Although the operating agreement does control the business. So depending on what is going on in your business, where you guys are at, I don't know. I think that it was a very interesting discussion that I would like to have with whomever this person is.
Because I think there are some risks that you would be supplanting some of the decision making now at this point, post filing. You could be supplanting some of the decision making that would need to go on in the family court. It just would be a weird situation. But you should have, look, I believe if you have children, for example, there needs to be an operating agreement because death and disability is an issue. So if you're trying to provide for children down the road, right, and make sure that the spouse is, but for your community interest in the business, I don't think you would gain anything through an operating agreement at this point. There are other reasons to have an operating agreement, but not necessarily driven by the divorce. That's, I guess, how I would answer that.
Yeah, I mean, I agree. Any other questions? We're at 11:02. For anyone who wants CLE credit, drop your email in the chat right now, please. And then we will know that we can send you a CLE certificate. And then if there's any other questions, also go ahead and drop those in the chat before we wrap up today. This has certainly been an interesting discussion. It's one of the most wild rides.
It is, and I would just leave you with, last question excluded, that really addressing this stuff ahead of time is really the key. Because once you're in it, it's too late to problem solve. It's a lot easier to problem solve at the beginning. And a lot of people think because they are either a husband and wife own the business, or because it's just a spouse that's owning the business, they don't need to deal with an operating agreement. And that's a fatal mistake. It really is.
Absolutely. Thank you everyone so much and have a wonderful day.
Thank you.
Thank you.
There's one other question that popped in that I just am going to stay on and address real quick, and then I'll pop off. So the last question here is, in the case that husband has made it so that wife does not need to work and leave her business and then made her entirely dependent on him financially, and then goes out and gets a probably $70,000 loan, and then they file for divorce, would wife be responsible for the debt? Okay, so husband and wife have a business. Wife is not working. Husband has a $70,000 debt. Is she responsible for that debt that he took out during the marriage? The answer is yes. Community property principles, if you acquire it, debt or asset during your marriage, it's community property. However, the court has to do an equitable division, which is not always equal. And if you don't, and one of the things that judges have told us is that arguing for a unequal division of debt because of the unequal amount of income is a reasonable argument. So you can argue, listen, husband makes $200,000 a year, wife makes nothing. She doesn't have the ability to pay back the $70,000 loan. He should take the loan. That's one way to do it. The other way you could do it is you could, I don't know how it's structured, but you could say the $70,000 loan has been used for the business and is a business debt and therefore goes with the business. And so if he takes the business, then he takes the debt. However, that's going to impact the valuation.
Yep, it will. It will. And then one additional wrinkle, in most cases, you're signing a personal guarantee. And you probably, as the spouse, have signed the guarantee. If you have not signed the personal guarantee, then that really means like that's a little weird. It's hard for the bank to collect because in our state, there's a statute that requires on guarantee or suretyship that wife or in property, real property, wife must sign or husband must sign. Both spouses must sign to be able to be bound.
All right. And with that, that's it for today. Have an amazing day. We'll see you soon. Bye.
Thanks. Bye.